Lawtorials.
Hey my Lawtorians, welcome back to Journey to Attorney. Today we are talking about the principle of ratification under the agency subject, and this is that moment where the principal says, well, I didn't tell you to do that, but I'm not mad at it either. Now this one's a quick one, but it's also a powerful one. It does show up on a lot of bar exam essays when agents overstep, but things still kind of end up working out. All right, so just going into it, let's start. Let's say you're a business owner and you're out of town and your assistant, who doesn't have authority to sign deals typically, goes ahead and signs a contract with a supplier. When you come back, you look at the contract and say, oh, wow, this is actually a very good deal. Let's keep it. You weren't supposed to do that, but this is a really good deal. I kind of get why you did it, right? Even though you couldn't get through to me, even though I was out of town, even though I didn't authorize you to do it. In that case, boom. That is ratification. So breaking down the definition, ratification is when a principal gives after the fact approval for something that an agent did without the proper authority. So to be clear, in order for ratification to come into play, the agent has to have acted without actual or apparent authority. There was no authority to act, but the principal later approves that action. So it can't be something where the agent had authority and the principal comes and sees it later and says, oh yeah, that's great. That's exactly what I was looking for. It needs to be after the fact approval. So in order for ratification to be valid, two things are needed. The first thing is knowledge of all material facts. Basically, the principal must know what they're agreeing to. You can't approve something blindly and then call it ratification. So the principal will need to know what was agreed to, what was signed, and they need to have all the knowledge of the relevant facts. And that is the first one you need in ratification. The second thing that's needed in order to complete the ratification element is affirmation through words or conduct. So this can be explicit, like, wow, this was such a good call on your behalf. I approve. Don't worry about overstepping. So that's explicit approval. Or implied. It could also be implied. So let's say accepting the benefits of the contract or continuing the business relationship. So a good example is, we've used event planning examples before. Let's say you're the boss and your assistant books a venue for your event without your permission. They couldn't get through to you. They end up signing the deal. They lock in the contract. They pay the deposit, do all the things necessary to get that contract signed. So then when you find out and you're back from your holiday or your vacation, instead of cancelling that contract and saying, actually, I didn't approve, you show up. The event goes on, you use the space, you pay the rest of the invoice. Through your actions, that would form implied ratification through your conduct, right? So make sure that when you're looking at these MEE questions and you see that, even though let's say the principal comes back from vacation and they're not so happy about the agent signing, tells them off, you should not have done this, but then you see they end up using the benefits of the contract, then they have impliedly ratified that contract through the conduct. So just moving on to undisclosed principles. Under ratification, it gets a little bit techie because we have the restatement second and we have the restatement third, and they both say different things. So the restatement second says an undisclosed principle cannot ratify because the agent wasn't pretending to even act on their behalf. How can an undisclosed principle that the third party didn't know existed ratify and approve something if the third party wasn't aware and the agent wasn't pretending to act on their behalf? Okay, that's what the restatement second says. However, under restatement third, it says an undisclosed principle can ratify as long as the agent was acting on their behalf, even if nobody knew it. So if you're in an essay and the MEE is not specifying which restatement to apply, you can actually use either and explain both. You'll still get the credit if you decide to, and this is how I dealt with it. I would say, well, in this case, under restatement second, since the principle was undisclosed, the principle cannot ratify. Whereas under restatement third, even though it was an undisclosed principle, ratification can still occur even if the third party didn't know that the agent was acting on the principal's behalf. All right, so use both. That's exactly how I handled it. I would explain both unless the question is explicitly telling me to apply restatement second or restatement third. So just be on the lookout for that. Now, I just want you to watch out because there are some cases that ratification can't actually apply. And these cases are, one, if the principal didn't know the key facts. Again, I said that's a requirement for ratification to actually be a thing. You need to know the key facts. So if the principal didn't know the key facts, then ratification can't apply. Or let's say the third party withdraws before the principal actually approves it. So if there was a contract, the agent was going to have it signed and you don't know about it. Let's say the deal was almost signed or they've signed the deal and you then find out, you're umming and ahhing, do I approve this? You're looking through the facts and that third party withdraws the contract and you haven't approved it yet. There's nothing to ratify because the third party has withdrawn, right? So just look out for that in the fact patterns. And then also another way it can't apply is if the original deal itself couldn't be authorized at the time that it was made. There was no way it could be authorized. If it was illegal or expired, the time had passed, let's say mailbox rule, and they hadn't accepted in time, or it just wasn't able to be a valid contract, in that case, ratification also wouldn't apply. Another thing to watch out for with ratification is that it doesn't automatically cancel out the agent's liability in the case that the principal was undisclosed. So this is one to watch out for. So always be checking for that disclosed or undisclosed principal. If ratification shows up, then you want to be thinking about that agent's liability and whether they are able to escape that or not. So I'll give you an example. Let's say an agent is booking a gig pretending to act alone, but they're actually working secretly for a celebrity and they're appearing as though they're the one booking the venue, they're the one signing the contracts, they're doing everything in their own capacity, or so it appears. If that secret celebrity that they're working for later approves it, even though there's ratification on paper, it seems like, okay, you did this without authority, I ended up approving it, ratified, right? I've seen all the facts and now I'm approving it after the fact. That seems like a standard ratification. However, the third party can still sue the agent because they didn't know that there was a principal even involved at all, right? They didn't know. How was that third party to know that the agent who's pretending to work on their own behalf actually has some secret undisclosed principal working in the background? So when it comes to liability, you're thinking of who is that third party going to sue? That person is going to go to the one person they've been dealing with who they think is working on their own behalf and sue that person. So in that case, the agent can still be found liable even if there was ratification on the principal's part. Okay, so just be on the lookout for that, and we will talk about indemnification and how the agent can have a chance at getting that money back if they are successfully sued by a third party, but we'll cover that in another video. That's it for today. For ratification, again, make sure you're looking out for whether the principal had knowledge of all the facts and whether they approved it at a later date, knowing all the facts, and the agent had no authority once they went into that deal. So just to recap on ratification, ratification is essentially when the principal says you acted without authority, but later down the line, they end up approving that action. Remember that the principal must, 1, know all the material facts, and 2, show that approval through words or conduct. Remember to watch out for those situations with undisclosed principals who might be able to ratify depending on the restatement, and that also the agent can still be liable even after ratification. So that's a wrap for this one. If you enjoyed it, please share it with a study buddy. If you would like to get your bar exam tea or your bar prep tea, head to shop.lawtorials.com. And if you need any help, I'm here. If you need just some clarity, if you would like tutoring sessions, just drop me a message, elelyon@lawtorials.com. Or if you're on YouTube, just drop a comment and I will respond. But keep studying, keep speaking life over your journey. And remember, I'm rooting for you always.
Lawtorials.